Welcome to another episode. Today, let's see if crying can get you out of a court sentence.
You are about to enter the courtroom of Judge Morty Durham Jr. The people are real. The cases are real. The rulings are final. This is his courtroom. This is Judge Morty.
Hold it. Who's yelling in her ear? Feltes, leave her alone. She's doing just fine.
Doing great.
All right. Ma'am, could you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. State your name again for the record, please.
I, Singletary.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of disturbing the peace. That is a misdemeanor. You can put your hand down. That's a misdemeanor, punishable by up to 90 days incarceration and a $500 fine plus court cost. Do you understand that?
Yes.
All right. You seemed unsure about that. You understand the maximum penalties, ma'am?
Yes.
All right. I also have to advise you that, and it was not signed off on here, this is not my case, so that it would be, you'd be taking a plea before, you'd be taking the plea before me, but you would be sentenced before Judge Barr in the 14A2 District Court in the city of Ypsi. You understand that, ma'am?
Yes.
All right. And understanding all of that, do you still wish to plead guilty to this offense?
Yes.
To the charge of disturbing the peace, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You went through with your counsel an advice of rights form and they signed it on your behalf. Is that correct?
Yes.
Do you have any questions regarding any of the rights contained on that form?
No.
I'd ask you to note that under paragraph 5 are all of your trial rights. You understand that you'll be giving up those rights as well as all the rights that are contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
All right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No.
You're doing this voluntarily
Yes.
and of your own free will,
Yes.
and also because you believe that you're guilty of this offense?
Yes. I do have a question.
Okay, I figured. All right, yes, go ahead. No, it's okay. What's the question?
Is it likely that I'll get the 90 days?
Okay.
I didn't hear the question.
Pardon?
I didn't hear the question, Your Honor.
Is it likely that she will do 90 days?
Ms. Singletary, we did discuss this earlier. Did you have additional questions on top of what we discussed earlier?
Okay, here's what I'm going to do. I'm not going to have that answered by you. I'm not going to have the attorney-client,
of course,
conversation on the record. It's a good question, and it's a question, quite frankly, Ms. Singletary, that you should ask, get an answer, be reasonably assured of the answer. If I were sentencing you, I could pretty much tell you what the likelihood would be, but you're being sentenced before another judge. Okay? You all right?
Yes.
Your Honor, I just want to note for the record.
Okay, Ms. Singletary, what's wrong?
It's just all scary.
Okay. All right, listen. Here's what we're gonna do, okay? I'm gonna, young lady, are you in school?
Yes.
You're at EMU?
Yes.
Okay, your only downfall is being up here near Ann Arbor and you come from Columbus, because I saw your address, okay?
Okay.
All right. What I want you to do is I don't want you to be worried about this, okay?
Okay.
There's a reason why they gave you this, and it seems to me that you also have a whole lot of questions about this, about things that may happen to you and what it all means, right?
Yes.
And those haven't, not that somebody didn't try, but those haven't been answered to your satisfaction, right?
Yes.
Okay, so here's what we're going to do. I'm going to adjourn this out a few weeks. Okay. I'm going to let you meet with your attorneys again so that what you can do is then have more of a conversation and get all of your questions answered. Okay.
Okay.
Okay. Will that help you out?
Yes.
Okay. So do that. And the other thing I need you to understand, and you'll ask your attorneys about it. There's an agreement on this to Homes Useful Trainee Act. So you may want to, because you're probably worried about doing this and what's going to happen in your future, what's going to do, whatever. So you might want to make sure that you have a full understanding of what that means. Okay? Because it can probably protect your future a little bit, which is why it's in this agreement.
Okay.
Your Honor, I just want to note for the record that I did discuss both the potential sentence in the matter.
I don't, counsel, sometimes it's not about us.
That is a correct statement.
You understand that?
Absolutely. Your
So
Honor.
I really don't need you to say anything.
Thank you.
It's about her. It's about her life. It's about a young lady trying to understand what may happen to her. You may have told her, you may have thought she would hear it, but she's probably maybe at that moment only hearing something else. So I don't need anything from you.
Thank you, Your Honor.
Ms. Singletary, I'm going to adjourn your probable cause conference to October 9th. Okay?
Okay.
2025 at 9 a.m., but it'll probably be in a different block, but I'll adjourn it to that time. You meet with your attorneys, get all your questions answered. Okay?
Okay.
All right. And then we'll see you on that date.
Thank you.
Ms. Singletary, you're more than welcome. You take care.